So you've decided to change your plea. That means your legal team has worked out a plea agreement that you are either satisfied with or need to take because it's better than the alternative, which is going to trial and losing and getting a less lenient sentence. A change of plea hearing is a fairly perfunctory event. All that needs to happen is that the prosecutor needs to put on the record what the plea agreement is. The judge needs to make sure you understand what it is, and then the judge needs to accept your plea. Before the judge can accept your plea, the judge needs to know several things. One, the judge needs to know if you understand the consequences of your plea, meaning the maximum possible sentence, both in as far as potential prison time is concerned, as well as any monetary fines that may be included, as well as other consequences, such as potential restitution, license suspension, depending on the crime that you may have been convicted of, or possible sex offender reporting if your crime is a sex offense. All of that needs to be put on the record because you need to know the consequences of your plea before you can enter a change of plea. Additionally, the court wants to know whether or not you're in the right mind. So the court's going to ask you some questions which might sound embarrassing, but all of the judges have to do it. They have to know whether or not you're on any drugs when you are changing your plea, which might affect your ability to understand what's happening. They have to know if you read, write, and understand the English language. They have to know if you've had enough time with your attorney, whether or not you've reviewed the evidence, and whether you're satisfied with your attorney's performance. Furthermore, the judge has to know whether or not you understand that by changing your plea, you're waiving your right to trial. Because when you waive your right to trial, you waive all of the rights that go along with that trial right. Those would include your right to force the state or the government to prove you guilty during a trial, either to a judge or to a jury. You also have to waive your right to confront and cross-examine the witnesses against you. You need to waive your right to have your own witnesses appear, or to compel them to appear through the power of a subpoena. You don't waive your right to an attorney, but you do waive your right to remain silent during the course of that trial without that being held against you. You have to make all of those waivers knowingly, intelligently, and voluntarily. You can't be coerced or threatened or promised anything in order to make those waivers. And as long as you make those waivers appropriately in court, the judge will finally ask you what your plea is. At that point, you'll change your plea from not guilty, the plea we entered at your arraignment, to guilty, which is a full and complete admission of guilt. Once you enter that plea, the judge will accept your plea of guilty, he'll find you guilty, and the case will be set for a sentencing hearing, or potentially your sentencing will proceed immediately. Usually we'll know the answer to that question before you change your plea. If you have any other questions or concerns, feel free and contact our office or utilize the frequently asked questions link that we've already sent you. Thanks.
Stand White, we fight